I'm Emily Galvin-Almanza, longtime public defender and author of the upcoming book, The Price of Mercy. Justice Clarence Thomas is out there speaking Latin, and I don't think you'd like what he has to say if you heard him say it in English. Here's what I mean. At a recent speech to Catholic University, which wasn't given a ton of coverage by the media, although maybe it should have, Justice Thomas talked about the principle of stare decisis, which is really the legalistic Latin-y way of saying what a court has already decided and what our courts have already decided holds. The next court to decide that issue has to kind of accept the prior understanding and interpretation that is already in place. The effect of that is what we think of as legal precedent, right? Once a court has already decided something, like, for example, that families have the right to contraception, or that people have the right to interracial marriage or to gay marriage. At that point, the subsequent decisions on that case have to respect the existing establishment of that right or permission or parameter of rights or whatever the prior decision is giving us. So when Justice Thomas made a few offhand remarks about stare decisis, it totally slipped under the radar of the mainstream media. But what he was saying was actually really concerning. Because what he was saying was he didn't believe that stare decisis is a be-all, end-all, that things can continue to be rethought by the courts. And that's actually, like, from a lawyer's perspective, earth-shattering. So maybe because he said it in Latin, and maybe because he said it in a very subtle way, the press didn't pick up on the fact that what we have here is a Supreme Court justice saying, hey, maybe we don't really have to pay attention to what the prior courts already decided for you, the people. Maybe we get to kind of just make up our new decisions, do some new things, keep inventing the world. And that's really disturbing for a number of reasons. First of all, let's start with this. We can absolutely acknowledge that in this country, we've had really bad court rulings that needed to be overcome. We've had court rulings that created separate but equal. We've had court rulings that interned Japanese Americans. We've had unbelievably bad court rulings. But there are legitimate ways to move past and change those rulings. Thing number one is the most straightforward. Congress can pass new laws. The Supreme Court decides something totally horrifying. We're supposed to have a legislature that can undo that by making a new law. I think we hear this a lot in the context of Citizens United, which allowed unbelievable amounts of dark money into politics. We have a Congress that could create laws about how corporate interests can control politicians and how they can't. There's a whole other conversation to be had about what's going on with that. But the point is that under our system of government, we are supposed to have lawmakers who can change the law in ways that are good for the people. The second way the courts can overcome a prior decision is by distinguishing it. Like, basically, you've got one side saying, hey, judge, there was this prior case where the same thing happened, and this case here, that's the exact same thing, so you've got to decide this case just like the prior judge did. And the other side might say, hey, this raven is not a writing desk, man. Like, this new case has all of these other features that the prior case didn't have. We can distinguish it. And therefore, you are free to make a new decision here. And then the third way is really a sort of analysis of how we perceive reality and what our shared values are and what are the material facts on the ground. When the material facts have fundamentally changed, it is okay for the court to say, hey, our understanding of the world is really different now, and we need an updated legal decision that reflects our new understanding of the world. If we come to a realization that we were really, really wrong about something, the courts are free to make a new decision based on our new understanding of the facts. They don't need to just scrap stare decisis. So the reason it's concerning that we have a Supreme Court justice out there saying, hey, we should rethink this, is that when we look at some of the precedents that are the most politically imperiled right now, Griswold versus Connecticut, which established the right for a family to have contraception and to plan how and when they want to have children. Loving versus Virginia, protecting the right to interracial marriage. Obergefell versus Hodges, which obviously established the right to gay marriage. These are all decisions in which no material facts have changed. We still know that all humans are human and deserving of equal rights and privileges in a fair society. So there's certainly no material change that could be used to make a new decision on these issues. And the other thing that's concerning about these precedents is that a lot of them aren't drawn directly from the language of the Constitution. Like, our founding fathers were not thinking about contraception. They had methods in those days, but they certainly weren't like making decisions about IUDs. So a lot of these cases that can sort of be conceived of as right to privacy cases, right? Your right as a citizen to have control over your personal life, your personal space, your home, your values, your family, your reproduction, your marriage. All of these are cases that are kind of drawn from what we would think of as the penumbra of other existing rights in the Constitution. They're not literally taken from the words. They are based on precedent. They arise from prior judicial decisions that are protected by stare decisis. Just to be very clear, this isn't an issue that only people who care about those decisions I mentioned should be invested in. Like, obviously, there are people on all sides of the political spectrum who have a vested interest in privacy-related cases. We can think of, on the conservative side, parents who believe very much in homeschooling and in the right to control their children's education. A lot of those protections arise from this idea of a right to familial privacy. So it's not like these rights are political. These rights are fundamental. Making that dipped toe, that Latinate dipped toe into scrapping precedent, something that should be concerning to everyone, although certainly there are clear political realities about the direction of our current court. That being said, we should probably all be a lot more concerned about power consolidation in the courts right now. And you may be listening to me thinking, like, Emily, the courts have no power, like, they rule against stuff all the time, and the Supreme Court overturns them, and like, does the administration even follow what the courts say? We don't know. They kind of just do their own thing and scrap it. Hear me clearly on this. The case we think about the most when we think about increased executive power right now is Trump versus United States. In that case, the court said that the president is immune from prosecution for their official acts. And the media covered this as an expansion of executive power, right? The president cannot be prosecuted. The president cannot be controlled. The president can go out there criming and no one can stop them. But actually what that case is an increase, not necessarily in executive power, though certainly on the surface it would be, but in the power of the Supreme Court. Here's why. Only official acts are protected with immunity. Who gets to decide what's an official act and what's not an official act? The Supreme Court. So the people who are going to bless certain actions on the part of the executive or curtail other actions on the part of the executive and even leave the executive open to subsequent prosecution, that's the Supreme Court. Our court has built its own precedents in a way to enhance its own power in a way that we have never seen before. So when we hear a justice of that court, of that uniquely powerful court in this unprecedented moment, saying that the way things were before may no longer need to be a guide to judges, a principle that has literally been a bedrock principle of our American system of laws, which is that judges respect precedent. It's a moment we've never found ourselves in before. And these little remarks at little covered speeches and conversations at universities somewhere in the country, they need attention, even in our fire hose of a news cycle right now, because these little offhand remarks are telegraphing what unprecedented times we might move into next. I'm Emily Galvin-Almanza. You can find me on 5 Minute News' YouTube channel or podcast. You can also find me on Twitter at Galvin-Almanza. And you can find me and my upcoming book at emilygalvinalmanza.com.